The court is now sitting. God save the United States and this honorable court.
We will hear argument this morning in case number 19-422, Collins versus Mnuchin, and the consolidated case. Mr. MOOPPAN.
Mr. Chief Justice, and may it please the Third Amendment, FHFA, acting as conservator of Fannie and Freddie, renegotiated the enterprise's financial obligations to Treasury. By replacing the enterprise's multi-billion-dollar dividend and fee obligations with a variable dividend tied to their net worth, the conservator eliminated any risk that a cycle could continue where the enterprise's obligations to Treasury would themselves cause draws from Treasury's capital commitment. The shareholders' statutory and constitutional challenges to the Third Amendment fail for many reasons, but there are three key defects that I'll try to address today. First, both claims are barred by the Recovery Act Succession Clause, which transfers to the conservator the authority to decide whether shareholders may bring derivative suits on behalf of the enterprises. The type of shareholder injury alleged here, that the corporation's assets have been unlawfully dissipated to a particular shareholder, is plainly derivative rather than direct. The shareholders have not cited even a single case to the contrary. Second, the statutory claim is barred by the Recovery Act Anti-Injunction Clause, which prevents courts from restraining exercises of the conservator's powers or functions. The conservator acted well within its authority in deciding that the renegotiation of the enterprise's financial obligations may have been appropriate to preserve and conserve Treasury's capital commitment. The shareholders cannot second-guess the wisdom or motives behind that business judgment. Third, the constitutional claim fails because President Obama had unrestricted power to remove and thus to supervise both of the officials who signed the Third Amendment. Treasury Secretary Geithner was, of course, removable at will, and so too was acting FHFA Director DeMarco. Thus, while the statutory restriction on the President's power to remove the FHFA Director is invalid, it had no prejudicial effect on the Third Amendment. I welcome the Court's question.
Counsel, you say that the common stockholders' claims can't survive because they're derivative, really claims of the corporation, and then barred by the succession clause. But it seems to me that they're a little different. According to the claims anyway, their stock value, their stock was completely wiped out in a unique way compared to the other holders of interests in the enterprises. In other words, that this action was directed at them as distinct from the corporation as a whole, therefore is not derivative, they claim, and shouldn't be barred. What is your answer to that?
So, as we cited in our reply brief, we've cited cases from the Delaware Supreme Court and from Judges Bork, Easterbrook, and Posner, all of whom recognize that when corporate assets are dissipated, that's a derivative claim even where the recipient is a shareholder, such that the financial effect...
but when you have, but when you have different categories of shareholders or people with financial interests, and the complaint is that the one class was particularly targeted, it does seem to me that that class has a unique claim that can't be characterized as just a claim of the corporation.
Well, Your Honor, I think that there's no reason to differentiate between a dissipation of corporate assets pursuant to a dividend payment versus a dissipation of corporate assets pursuant to a side transaction. In the cases that we cited in our reply brief, each of those cases involves certain shareholders being treated better than other shareholders, and it shouldn't make any difference for purposes of a derivative claim whether that special treatment occurs pursuant to a side transaction or through a dividend payment.
Maybe shareholders being treated differently, but when the way you're being treated differently is that you're completely wiped out, the corporation doesn't have any particular interest in the balance, it seems to me, or at least not the same sort of interest as the shareholders who are left out in the cold.
Well, I think the harm here is in the first instance to the corporation. The claim is that the corporate assets have been dissipated. So the corporation does have an injury. And I guess one way of making the point I've been trying to make is I think the shareholders would have the exact same objection if Fannie and Freddie had entered into a contract with the Treasury Department where they bought a commemorative coin from the Treasury Department and paid them for that all of their net worth in perpetuity. That would be exactly like the claims that we cited in our reply brief where you had a side transaction to one shareholder to the disadvantage of all the other shareholders. And that's there's just no difference for purposes of a derivative claim whether the harm to the certain shareholders comes because of a side transaction or pursuant to an amendment to the dividend obligation.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Well, counsel, would you, perhaps this is redundant, but give us another example of what direct would look like rather than derivative?
So direct claims are claims where the injury to the shareholder doesn't turn on a harm to the corporation. So, for example, if shareholders are injured in their right to vote, that doesn't implicate the rights of the corporation. It is a direct shareholder claim. The cases that have recognized direct suits where shareholders are harmed tend to be in those sort of contexts where there's a dilution of, for example, voting power. That's what the Delaware Supreme Court laid out in its El Paso case. Mere harm to shareholders because the corporate assets have been dissipated is a derivative claim. Harms to the shareholders' ability to do things that don't turn on a harm to the corporation first, those are direct claims.
Well, what if you had, and I know this agreement doesn't say this directly, but an agreement that simply transferred directly all dividends from existing shareholders, say, to Treasury, that it explicitly said that? Would that be, I think it's rather odd that that the shareholders' dividends can be jeopardized or depleted. And that's not a direct claim, but the right to vote on corporate matters is a direct claim. So what if it was more explicit? What would you say to that?
So I think that would be different. I think the difference is it's not a question of being explicit versus implicit. In your hypothetical, they are acting directly on the shareholders' contractual rights to dividends. That doesn't harm the corporation at all. Maybe one way of thinking about it is it's the difference between the size of the pie and the share of the pie. The claim here is that the corporate assets have been dissipated. That is a question about the size of the pie, and that is a harm to the corporation. In your hypothetical, what has been changed is the share of the pie. There's been a direct action on the shareholders' rights to dividends that's been transferred to another shareholder. But importantly, that's not what's going on here. It might be the effect. Whenever the corporation has less assets, that's going to affect shareholders' ability to get dividends, no matter why the corporation's assets have been wasted or stolen. And, Judge Posner's opinion in the Seventh Circuit lays this out pretty clearly, that when you have a harm to the corporate assets, it just doesn't matter why the assets have been dissipated, whether it's by theft or a conflict of interest or a side transaction. In all events, the harm is in the first instance to the corporation, not to the shareholders.
Thank you.
Justice Breyer?
Thank you. I think in reading this, you could, with trying to simplify as much as possible, view the shareholders' claim as saying, we bought into this corporation. It was supposed to be private, as well as having a public side, and then the government nationalized it. That's what they did. If you look at their giving the net worth to Treasury, it's nationalizing the company. Now, whatever conservators do and receivers do, they don't nationalize companies. And when they nationalized this company, naturally, they paid us nothing, and our shares became worthless. And so what do you say?
Well, Your Honor, what the Third Amendment did is it renegotiated the enterprise's financial obligations. The enterprises were saddled with
No, I know that. But what I wonder is, is it fair to characterize it not with this more legal language, but just saying, look, they nationalized it. They gave the company away to the Treasury. Who do you think the Treasury is? It's the government of the United States.
Right. And what I
was... One will really look into this, and you'll discover they didn't get enough money for it. They did it at too cheap a price. They did it, and they paid us nothing. All right. But can I view this as nationalization?
No, Your Honor, because what the agreement does is it replaces a $20 billion a year dividend. So the enterprise is already owed to the federal government $20 billion a year.
Yeah.
What the conservator did was say, rather than having
that goes to the reasonableness of the agreement. They say, okay, let's have a trial on that. They think it's a very reasonable thing to do. We don't.
And the point is the anti-injunction clause doesn't expose the conservator's business judgment to reasonableness review. The question is whether they've exceeded their powers.
But they say nationalization is not the kind of thing conservators and receivers do. And therefore, you can examine it. And when you examine it, you will see how unreasonable it is.
Your Honor, what the enterprises did was they renegotiated financial obligations. That is what they did. Whatever label the plaintiffs want to put on it.
No, that was my fault.
What the actual power that was exercised here was a renegotiation of financial obligations. That is what conservators do day in and day out. Now, the terms of this renegotiation are fairly unique, but that's because the enterprises were in a fairly unique condition. Most companies don't owe $20 billion a year to the federal government. And so when they switched that, and they switched it to ensure that there was no risk to the $250 billion of capital that Treasury had committed to these enterprises. That is the nature of the agreement here. It is an unusual agreement, but it is still, at the end of the day, it is a renegotiation of financial obligations. That is a heartland exercise of conservatorship power. And if the anti-injunction clause means anything, it means that you don't second-guess whether they could have done it a different way, whether it was a bad deal, whether they did it for bad motives. At the end of the day, what they did is they renegotiated financial obligations.
Justice Alito?
If we agree with you about the removability of an acting director, and also agree with you that the only relevant action was one taken by the acting director, would we have any reason to address the question whether the restriction on the removal of a confirmed director is constitutional?
Well, yes, Your Honor. The Court of Appeals, in addition to declining to set aside the Third Amendment, did issue a declaratory judgment that prospectively the FHFA removal restriction should be set aside. Petitioners here did file a cert petition where that is the first question presented. We think the court should confirm that that was a correct holding, that that removal restriction is invalid and shouldn't be applied prospectively. But we do think that it is no basis to set aside the Third Amendment, both because the acting director is in fact removable in a will.
Well, perhaps if it's legally irrelevant, it could be vacated on that basis without reaching the merits of the question. But let me ask you this. What is your response to the argument on the other side that confirmed directors took actions pursuant to the amendment, and therefore we have to consider the status of confirmed directors?
Your Honor, I don't think they've actually ever challenged any action enforcing the Third Amendment by confirmed directors, and I don't know what those actions would be since it's ministerial. The Third Amendment requires the dividends, and most maybe the only thing I can even think they might be talking about, though I'd be curious what they have to say, is whether to pay the dividends under the Third Amendment in cash or instead in kind through the liquidation preference. That wouldn't do them any good either way, so I'd be surprised if that's what they're challenging. But other than that, I don't know what it would be that they'd be referring to.
If we were to reach the issue of the removability of a confirmed director, and if we were to agree with you on that question, what basis do you have for distinguishing between the relief that you think is appropriate in this case and the relief that was provided in cases like Bowsher, seal of law, and appointments clause cases where an appointments clause violation was found?
So I think the most significant difference is the fact that in this case, the Treasury Secretary was a party to the action that's being challenged. Their constitutional claim is a claim that the agency action was unconstitutionally insulated from presidential supervision. And unlike in all of the cases you just mentioned, here, one of the parties to the contract is the Treasury Secretary, who, of course, is removable at will by the president, is the president's right-hand man. So no one can say that the president didn't have sufficient control over this agreement. And that's why if the APA's prejudicial error rule means anything, it means you can't set aside a multi-billion-dollar agreement on the theory that the president didn't have enough control over it when the president's Treasury Secretary signed it. That's
Justice Sotomayor?
I just want to make sure that I get the gist of your argument, and I think I have it right. I know you and the shareholders disagree on whether this deal had a reasonable cause. But let's posit a deal that didn't. For no rational reason, the FHFA sold all of Fannie and Freddie's assets in exchange for $1 to itself. It did exactly what Justice Breyer said. It nationalized things. It nationalized the company. Your position is that there is no court review of a decision by the FSH as conservator that could give shareholders the right to challenge their action.
So we think, in a hypothetical like that, we think you could. We don't think the anti-injunction clause would bar a claim that actions were taken that have no objective, rational justification of being taken to preserve and conserve assets. We do think that even that claim would be barred by the succession clause because it would still be a derivative suit. But if the court disagreed with us about the succession clause, we aren't arguing that the anti-injunction clause means that there's no review of anything the conservator does. We are just saying that when the conservator takes actions that may be appropriate and necessary to preserve and conserve assets, there's no second-guessing the business judgment. And I think that's an important point here.
All right, counsel, let me just stop you there. If the company is still in existence but owned by the FHA, there is no claim. My colleagues have posited something close to this. But it is the shareholders who have been kicked out for no business reason. I don't see how that's a derivative suit that the succession clause would bar.
It's because the shareholders' harm is derivative of the harm to the corporation. All they have lost.
No, the corporation's not losing its profit. The corporation's actually may be gaining money by not paying out dividends to the shareholders, but it's the shareholders and not the company that's being deprived of a profit.
Well, I don't think that's right, Your Honor. Their claim is that Fannie and FHFA acted improperly in giving away the assets of the corporation.
All right, counsel, I just want to get in one last question. Your argument is that the FHA is unconstitutionally structured, given this court's decision in Sheila Law. I see vast differences between the FHFA and the CFPB. The FFA's most notable power, and the reason we are here today, is that they can put certain government-affiliated companies under conservatorship. Conservatorships are never thought of, in my experience, as an executive power. It's historically been an adjunct to the judicial power. So why isn't that, and this is not a wide-reaching power that affects many entities. It's one company at a time, essentially, unlike in the CFPB. So why can't we say that this is an exception to Humphrey's estate or Morrison versus Olson?
Briefly, counsel.
The question is whether it's significant executive power and the authority to decide whether to put Fannie and Freddie into conservatorship or receivership, a decision that affects the entire mortgage market and thus the home equity of every homeowner in this country, is unquestionably a significant executive power.
Thank you, counsel. Justice Kagan? Justice Kagan?
Sorry. Mr. MOOPPAN, can I take you back to your answers to Justice Alito? If I understood you right, you said that the only final action that's being challenged here is the Third Amendment. So I'm going to repeat his question to you because I wasn't quite sure I got your answer. If that's the case, that that's the only final action challenged here, what basis would we have to do anything more than issue a declaratory judgment about the validity of that amendment?
So I don't think you have it quite right. The plaintiffs in this case did seek a declaratory judgment that the structure of the FHFA was unconstitutional, and the Fifth Circuit granted them that relief, and there is a cert petition that was granted that includes that question. So we do think it would be appropriate for this court to confirm that that aspect of the judgment is correct.
No, I know that they asked for it, but usually if you bring an APA challenge, you have to point to a final agency action that you think is wrong in some sense. And here, the Third Amendment was done by the acting director. If you are right about that, it doesn't raise the removal issues. So what does raise the removal issues?
So it's just like Free Enterprise Fund, Your Honor. They are entitled to bring a prospective suit saying that the ongoing regulatory power of the agency over them, even absent a concrete final agency action, they can seek prospective relief against that because, of course, the FHFA, as a regulator, has the authority to decide whether these entities will continue to be in conservatorship or not, or whether they could be put into receivership. The shareholders here have the ability to say that that decision should be made only by a regulator that's constitutionally structured. Just like
you're saying that that's true even if they're not pointing to any particular actions in the period when there was a confirmed director that they object to?
Well, it's a prospective suit, Your Honor. So their point is that every regulatory decision FHFA makes going forward, including most obviously, most importantly, whether to keep the entities in conservatorship or receivership. Just like in Free Enterprise Fund, the court allowed a prospective suit, even though by then the investigation was basically done. The point is that you've got a regulator, and a regulated entity, or the shareholders of a regulated entity, can bring a claim to say that that regulator is unconstitutionally structured as a prospective matter. But you are right.
Thanks. Justice Gorsuch?
I guess, counsel, I'm a little confused at this declaratory judgment with respect to future action. Seems to me like it would be appropriate for hanging on the wall, but not much else. The plaintiffs here have sought a declaratory judgment in aid of further remedies, retroactive remedies that might actually do them some good, and that's the Third Amendment. And I guess I'm a little confused why we wouldn't proceed to hold that the Third Amendment was void from the beginning by virtue of the Appointments Clause problem. That's pretty much what we did in Lucia, as you'll recall, where we vacated the ALJ's decision. Why wouldn't we do the same here?
Well, again, because their claim is that the Third Amendment was unconstitutionally insulated from presidential supervision, but that claim is clearly wrong on the merits because the Third Amendment was signed by the Treasury Secretary.
So it's a merits determination then?
Yeah, we're not making a standing argument. We're saying,
and then with respect, if it is, then why isn't it? It's a harmless error argument, as I understand it. But we don't do harmless error in structural constitutional cases typically. And if we did, isn't it rather speculative to say what would have happened here if we would have had a different director who was actually subject to presidential oversight and the political process, especially when Congress insulated this person, in theory, from that process? Isn't that a degree of speculation that's quite beyond us?
I don't think it's speculative at all, Your Honor, because, again, this isn't a decision just by the FHFA director. It was signed by the Treasury Secretary. The Treasury Secretary...
I understand that point, but if Congress decided to put this person separate from the political process for a reason, and might have been to insulate them all from the blowback that might come. Who knows? I don't know. You don't know. None of us knows. And isn't that the whole point? And what do we do, again, just to return to my fundamental question, is why isn't this void? When we have the Federal Vacancies Reform Act, for example, says that an action taken by somebody who's without power is void, not just voidable, not ratifiable, it's void. Why wouldn't the same be true here?
So in addition to my point about the Secretary of the Treasury, I guess I would say even from the other side of the coin, this was done by an acting director, and an acting director is also removable at will by the President.
I understand that argument. Put that argument aside. Put that argument aside and your harmless error argument aside. why wouldn't this be void?
Your Honor, if you reject all the arguments we've made, then I suppose we would probably lose. But
okay, all right. So I've got it. It's a harmless error argument on the one hand, I've got it. Okay, those are your two arguments. That's it. After that, it's void.
Well, in addition to our, antecedent arguments about the succession clause, which I want to focus on the merits.
Correct. But I got that. But when we come to remedies, it's either the acting director is reportable to the president, or it's harmless error. I've got it. Thank you, counsel.
And I would, Justice Kavanaugh.
Thank you, Chief Justice, and good morning. You were saying something there. Why don't you continue on?
Thanks. Yeah, so I would like to talk a little bit about the acting director point, because I think it is an important point, and it avoids some of Justice Gorsuch's concerns about the Treasury Secretary side. The statute does not expressly provide that the acting director is subject to the same cause protections as the confirmed director, and this court should not read a statute to create constitutional problems. It normally reads statutes to avoid constitutional problems. So an easy solution that avoids all the concerns about structural error and speculation and all the rest is to simply say that under this statute, the acting director, who is the official who took this decision on behalf of FHFA, is in fact removable at will by the president, and so there's no problem to begin with.
Is that true of all acting officials?
I'd have to look at any given statute to tell you the answer, Your Honor. But
well, I guess, is it true, is your principle that you're asserting there that acting officials are presumptively removable at will by the president unless the statute with respect to the acting director or acting official himself or herself specifically puts restrictions on the removability?
Yes, our general position is that you should not leapfrog from any cause restriction for a confirmed official and assume that that extends to an acting official. You would have to always look at the provisions that govern the acting official and see whether there's a removal restriction for them. That's both as a matter of constitutional avoidance.
Leave. Would it follow that everything done thereafter by the director is void ab initio?
Well, Your Honor, I think that would obviously mitigate the concerns over the president being the cajoler in chief and not having sufficient control over the agency. There'd still be a residual concern that, well, the director might change his mind and then he's got this legal protection. And so there still might be some issues about accountability and liberty, but it certainly would be a much less problematic situation than what we have here.
Well, I do think we have to answer that question in order to determine whether it follows that the identification of an unconstitutional restriction on removal necessarily means, because it is a structural defect, that everything done by that officer is void ab initio.
Well, Your Honor, we do think that this qualifies under Weaver for being a structural error for two reasons. Number one, their interests beyond the outcome that is produced. There's the interest in accountability. And also, it's hard to measure the effects. That's why this court, presumably in SELA law and free enterprise, said plaintiffs don't have to create a but-for world. Federal courts aren't well suited to psychoanalyzing coordinate branches of government and what they would do in a hypothetical world. And so where it's hard to measure the effects, and that's particularly true here, where, again, it was a negotiation between a Republican appointee and the Obama administration, and they had bitter disputes throughout the 3 years that Mr. DeMarco was there.
Well, it is hard to measure the effects, but sometimes we have to do things that are hard. Suppose we were to agree with Mr. Nielsen that this can't be distinguished from the head of the Social Security Administration, or suppose we were to overrule Humphrey's executor, as some members of the court have suggested. Do you think it would follow that everything ever done by a Social Security administrator or everything ever done by the FCC or one of the other multi-member commissions was void ab initio? They would all be wiped off the books?
Your Honor, as I understand it, in free enterprise, the court left open the question of if it's a lower-level employee who made the determination at the Social Security Administration, whether that would have to be voided. But certainly, yes, our position is everything done by the principal officers of those agencies would be void. Of course, there'd be the statute of limitations in Article 3 that would limit what would have to be thrown out. And, of course, in Noel Canning, this court invalidated 20 months of the NLRB's activities.
Well, do you think that if a provision of a massive statute is held to be unconstitutional, a person who is not in any way affected by that provision is entitled to relief?
Well, if they've suffered Article 3 injury at the hands of that person, and it's a separation of powers case, I do think it should be void, given the broad prophylactic protections that separation of powers protect.
Thank you.
Justice Sotomayor?
I want to follow up a little bit on Justice Alito's questions. It does seem counterintuitive, perhaps illogical, to say that assuming you're right that the FHFA director must be removable at will, why you should get anything more than a declaratory judgment to that effect. First, the argument is that if this decision was entered into by two entities under the complete control of the president. There is no dispute that the Treasury treasurer is removable at will. So we know what the president would have wanted because he had an agency he fully and unequivocally controlled entering this agreement. And then secondly, we have an acting director, which almost logically means that he could be removable entering it. Second, no president has ever tried to remove the director, acting or otherwise. So given those circumstances, I am not sure how this agreement or even how the at-will termination affected you.
Well, Your Honor...
why you're entitled to an unwinding of an agreement that was entered into, assuming we rule against you, that had a valid or a reasonable business reason for being entered into.
Your Honor, respectfully, we don't know what the president wanted. We know the president was willing to sign this deal. Otherwise, the Secretary of Treasury wouldn't have signed it. But as my friends on the other side said, it took two to tango. This was a negotiation, and it was a negotiation with a Republican appointee with whom relationships had gotten so bad that on our red brief at page 72, we point out there was open calls for him to be fired, and the administration said he's an acting director and we can't fire him. And presumably that's because of 4511A that says it shall be an independent agency of the federal government. And under this interpretation that the acting director can be fired, it would toggle back from being a radically independent agency to a radically dependent agency. My friend on the other side points to the Swan case, but that was the NCUA, and there were 3 board members, and the fact that one of them became dependent didn't transform the agency radically. Here, when you have a single director and you say that the acting director can be fired at will, then you just radically transform the nature of it. In addition, even if I'm wrong about that, under 4512F, the president's hands are handcuffed in terms of whom he can designate, and we do challenge the actions of the regulator. So for all those reasons, we're entitled to relief. Certainly, backward-looking relief was given in the Basher case as well.
You argue that the APA eliminates any need to look into whether a shareholder's injury is derivative of an injury suffered by the corporation. Do I take it that you're taking the position that anyone holding a single share in a company can challenge any agency action or rulemaking that affects the company's stock price?
Your Honor,
that would seem to me as a sea change in how administrative law challenges are litigated.
Your Honor, this was a concern that the American Power dissent articulated, and 75 years later, it hasn't come to fruition. And I think because of cases like Air Courier, there you have the Postal Service with a monopoly on international air routes. The employees came forward when that monopoly was lost and said, that's going to hurt us economically. And the court said, these employees aren't within the zone of interest. But HERA is different because it's highly protective of shareholders' rights. We see that in the rehabilitative mission of the conservator. We see that in receivership, where there's a priority scheme as to how the money can be distributed. And we see that in the preserve and conserve mandate. And we see that in 4617 B11E, which requires the conservator to maximize the net present value of asset sales. That protects shareholders more than anyone because they're at the bottom of the waterfall.
Justice Kagan?
Getting proceeds.
Mr. Thompson, let's go back to Justice Alito's question about the Social Security Administration. And I'll put some scary-sounding numbers on this. The SSA has been led by a single commissioner since 1994, and ever since then, it's rendered 650,000 decisions every year. So that's about 17 million decisions. Now, you told Justice Alito, well, maybe there's some exception for lower-level employees. I'm not sure that AOJs would qualify as that. And even if they do, let's assume, which I think is probably true, that all of those decisions are rendered pursuant to guidance and rules that the SSA commissioner has enforced. So are we really going to void all of those decisions?
Well, Your Honor, a few points. Number one, there's the statute of limitations and the Article 3 limitations. There's also the fact that the SSAA is different than the FHFA. We don't think it makes a constitutional difference, but it has much more limited jurisdiction. It's not running multi-trillion-dollar companies, and so to the extent the court wants to try to preserve the Social Security Administration, it could potentially try to do that. We don't think it should. We agree with the Solicitor General that it's unconstitutional, and that, yes, its actions within the statute of limitations should be void if done by principal officers.
It's a little bit odd because, I mean, none of us really think that any of those decisions would be different if there were a different level of presidential supervision, do we?
Well, Your Honor, I think that's right. That was Lucia. In fact, as I recall, it was precisely because it wasn't thought that there would be different that a new ALJ was assigned on remand.
No, I mean, I think Lucia is a different question. It's an appointments clause question. We can come back to that. But I mean, are you really making a good faith argument that if there were at will removal of the Social Security Administration, that these 17 million decisions would come out differently, or indeed that any of them would?
Your Honor, I understand, and highly likely that they would not. But the same was true in Stern and Marshall. It was very unlikely that the bankruptcy judge, if he had had Article 3 protection, would have come out a different way on that state law counterclaim, and yet still relief was provided. And likewise in SELA law, it was very unlikely that if the president was able to fire the head of the CFPB, that subpoena to that law firm would have come out any differently. So that's sort of a feature.
In a case like this, Mr. Thompson, where we're trying to figure out the proper remedy, I mean, it's a kind of equitable question, isn't it? And we're trying to figure out what position you would have been in absent a constitutional violation. Why isn't that the right question?
Well, I think footnote 12 of Free Enterprise and SELA law just last term rejected that. They said plaintiffs don't have to try to recreate a but-for world. And here it shows why. We'd have to go back to 2009 and see what would have happened if Director Watt, for example, had been there throughout the entire time. And, would the president have preferred to keep the money at Fannie and Freddie and spend it on affordable housing rather than send it all to the Republican-controlled House of Representatives and the Treasury? So that's a difficult...
Does that mean, Mr. Thompson, that we have to do a great deal more than invalidate the Third Amendment and everything that's followed from it? I mean, why shouldn't we go back to the first or the second?
Well, Your Honor, we focused on the Third Amendment because that's the feature of this that rearranged the capital structure. But as we made clear to the Fifth Circuit Court of Appeals, we are perfectly content with all of of these arrangements, which, as we say in the complaint, were a concrete life preserver. It's like getting a credit card with a double-digit interest rate that you can't repay the debt on. It's not debt, but you can't pay the money back. And so we would be perfectly content with it being thrown out.
Justice Gorsuch?
Counsel, your remedial ask is a big one and hard for us to swallow, I know. And I want to focus on a couple aspects of it that that are particularly important. The first is that once we had a new director in 2014, we've heard a suggestion that you haven't complained about actions taken after 2014 in your complaint, and the only complaint has to do with the entry into the Third Amendment, which took place during the pendency of a prior director. I'd like to understand your thoughts about that first, and second, whether a new constitutionally correct director that we ordain today could ratify the actions of an unconstitutional arrangement previously. Why would it have to be void?
Yes, Your Honor. So on the first question, we do complain about the implementation. We are complaining about each and every one of the decisions under the net worth sweep by the director. Every one of these dividend payments gets declared quarterly, and none of them can be paid to the Treasury under 12 CFR 1237.12 A and B unless the director blesses those. And so we've complained in the complaint that but for each and every one of those payments, there'd be $124 billion of extra capital at the companies. Obviously, the implication of that calculation in our complaint is we're not satisfied that any of these payments were made. Now, as for the court's second question with respect to ratification, we don't believe this could be ratified, in large part because it's the government who's coming in and trying to justify this by saying, well, there was a death spiral. We didn't know the companies were going to do so well. Well, now we know. We know that they're thriving in terms of their profitability, not soundness, because all the money's being siphoned off to Treasury. But we don't believe it could be ratified now, Your Honor.
I guess I don't understand that latter answer. A lot of facts in there, but what legally, what constitutionally would prohibit the ratification?
Well, when the underlying rationale that the government has proffered is now 8 years later been totally exposed to have no validity, then we don't see how the government could sort of time travel back and nunc pro tunc bless that.
And I guess I'm asking why not. I mean, I understand that like the Federal Vacancy Reform Act says that can't be done when its terms apply. But why couldn't we, as some sort of equitable, remedial dodge, do that here?
Well, I think the plain language of the APA, which says that the unlawful action shall be set aside, of course, with due account being taken for the rule of prejudicial error. But as we've talked about earlier today, this is structural error, not harmless error.
No, that really wasn't my question.
Okay, I'm sorry.
Fine. If you have any further thoughts about why it couldn't be ratified, I welcome them. But let me just pose you one last question. And that is the argument that, of course, the president could have fired the acting director because the Vacancy Act would normally apply, and that would permit him to do so.
Well, at this point, the Vacancies Act did not apply because it had been more than 210 days since the Senate had rejected the nominee that President Obama had sent up. And so the FVRA just had no application at the time of the net worth sweep.
Any reason why, just that we shouldn't, as a background principle, assume that the president could?
One reason would be Wiener. Wiener said that you look at the nature of the function of the office that's vested in the officer, and I know some might think Wiener wasn't correctly decided as an original matter, but Congress is entitled to legislate against the backdrop of this court's precedents. And so the Wiener precedent said, here's how you can apply it. Look to the act, to the nature of the functions. It's identical, the powers of the acting director and the regular director, and we've got the plain language of 4511A, which says shall be.
Yeah, thank you.
Justice Kavanaugh?
Thank you, and good morning, Mr. Thompson. Picking up on the first part of Justice Gorsuch's questions, the Solicitor General the reply brief on the remedies question starts with Marbury and says, since Marbury, this court has continued to subject structural constitutional claims to the general law of remedies, that courts may deny relief on such claims as a result of estoppel, de facto officer doctrine, ratification, failure to make a timely objection, or the grant of a stay. And then says that you've cited other cases where the court has vacated actions taken by unconstitutionally structured agencies, but the Solicitor General says those cases show only that vacator is permissible in an appropriate case, not that it is mandatory in every case, and that those principles I've just mentioned can apply. Your response to that?
Well, number one, they haven't invoked, for example, the de facto officer doctrine. They haven't invoked that in this court, so they've waived that. The only thing
your reaction to the general catalog of principles outlined by the Solicitor General.
I don't believe that it applies in a case brought under the APA. Obviously, many of the older precedents before 1946 and even some after weren't under the APA. But when the APA says shall set aside with due account for the rule of prejudicial error, that sweeps aside these equitable doctrines and tells this court that it shall set aside.
Okay. And then switching gears on some of the arguments made by the amicus, the forceful arguments made in distinguishing seal of law and other precedents. I want to get your reaction to a couple of those. The amicus points out that seal of law used the phrase significant executive power. Your response to that, was that a descriptive language, or is that a necessary condition before we can say that a for-cause removal restriction on an executive officer is unconstitutional? The amicus says the latter.
Well, we certainly did not understand this court to be creating a sliding scale, which would require lower courts to go and try to figure out how much is a significant executive power versus not. So we did not understand it to be establishing a legally required standard. If it were, there's certainly significant executive authority being exercised.
Sorry, can I stop you there? Another distinction that the amicus points out is that the for-cause language here is not the same.
Well, that's true, but Wiener tells us what the term for-cause means, and it says rectitude, which is moral failing. So it's different, but in some ways it's even a higher standard than what was before the court in seal of law. Moral failing is a smaller subset than neglect and malfeasance.
And then the amicus says on a different front that the implications for other agencies could be significant and that the court could not limit its holding here to single director independent agencies and leave those for another day. Whether those follow or not would still be an open issue. What's your reaction to amicus's point that this would necessarily carry over into multi-member agencies, at least with chair designations and things like that?
We disagree with that, Your Honor. We think we fall comfortably within the seal of law framework, and there would be no reason for the court to go back and redo that framework. So we disagree with it.
Thank you.
Justice Barrett?
Mr. Thompson, I want to just make sure I understand the breadth of your argument for structural error. Let's assume that we think that the acting director was removable at will, there was no constitutional problem with the acting director. Let's further imagine that the acting director is the one who is in charge for, say, up until 6 months ago, up until last year, and then we had a confirmed director. Does that mean that everything that happened in the course of the Third Amendment is then void, as structurally invalid because at some point a constitutionally invalid officer entered the scene?
Well, Your Honor, if it was an acting director and all of our arguments are rejected about 4512F as well, and so that the court concludes there was no structural problem whatsoever at the agency until just 6 months ago, certainly we would complain about the last 6 months worth of payments, but it's been many years that there's been a Senate-confirmed director.
No. I understand that. I'm just trying to figure out how much participation by the unconstitutional officer matters. I mean, because here we didn't have constant 100% of the time of control by a confirmed director. But you're arguing, I mean, and I'm saying, let's assume that we think the acting director posed no problem. If the Third Amendment was entered into by the acting director with no constitutional problem, you're still saying that the participation of the confirmed director was a structural error that invalidated the Third Amendment and everything with it, correct?
Well, it certainly it affected the implementation, yes, Your Honor. That would invalidate any implementation by that illegally constituted director.
But only for those periods, so it wouldn't actually throw the whole thing out, it would just invalidate those actions taken by the confirmed director?
I think that is a fair point, that the director can only be, their actions can be invalidated. The director's actions that he took could be invalidated, but not his predecessor, if what his predecessor had done was totally permissible.
And so we would then have to parse through and figure out what was done by the constitutionally problematic officer and what was fine because it was done by the acting director?
Well, if, and again, it's a big if the court concludes there's no problem with 4512F, then the court would want to look to see what did the director do, and that stretches back to 2014, these approvals.
And let me I just want to be certain that I understand what you're asking for. Are you asking us, say, if we agreed with you on the whole thing, do you want an injunction ordering Treasury to pay back the billions of dollars?
No, Your Honor. So this is very important. We're seeking two things. Number one, we're seeking prospective relief so that in your hypothetical, the Senate-confirmed director would be enjoined from making any future approving any future sweep dividend payments. And number two, we're asking to go back and have the overpayments over and above the $18.9 billion to be treated as a pay down of principal. And that would essentially deem the government paid back.
Thank you.
A minute to wrap up, Mr. Thompson.
Yes, Your Honor. For decades, federal conservators and receivers have exercised powers under statutory schemes that are indistinguishable from the one at issue here. Yet no conservator or receiver has ever before been permitted to operate its ward for the exclusive benefit of the federal government. And so I will close with the words of Mark Calabria, FHFA's current director, quote, "Fair and predictably applied insolvency rules allow investors and creditors to judge the risks of investing in a company. If that process can be manipulated to favor one creditor, as FHFA has favored Treasury, then there is no basis to judge what could happen if a company fails. Given the important role that government bodies play in the resolution of many financial institutions, it is essential that the performance of this role assure all stakeholders of fairness and predictability." Close quote. We agree. Thank you.
Thank you, counsel. Rebuttal, Mr. MOOPPAN.
So my colleague hasn't shown any presidential insulation on either side of the Third Amendment. With respect to the acting director, he hasn't shown any reason why this court would construe the statute to create a constitutional problem rather than to avoid one. The only point he really made was to say that once the acting director was removed by the president at will, the president had limited options for who could replace him. That's not a problem about presidential removal. It's not the claim they made, and it's actually not even correct because the FVRA is available. On the other side of the transaction, it's undisputed and indisputable that the Treasury Secretary signed the agreement and, of course, is removable at will by the president. His only argument on that side is to say, well, maybe the contract wouldn't have happened because of other things that happened earlier. But that can't be right either, because on that theory, the agency could never act going forward. Think about, for example, the CFPB. On his theory, even though this court has said that the CFPB is now removable at will, the CFPB can take no further action going forward because someone could always walk into court and say, well, the circumstances would have been different if they hadn't been subject to a removal restriction in the past. That's not the way this court's judicial review works. The question is whether the agency action that's being challenged was insulated from the president. And here, because the Secretary of the Treasury and the acting director, the ones who entered into the Third Amendment, it was. So then if we assume the Third Amendment is valid as a constitutional matter, his fallback argument is to suggest, well, the implementation of the Third Amendment at least can be challenged. And the reason that doesn't work is because once the Third Amendment is valid, the money is owed. The only payment of such dividends and whether or not dividends are declared. A simple analogy to make the point, imagine a cabinet secretary entered into a contract to buy property and would pay for it for 5 years, $1 million a year. And then imagine 2 years in, Congress imposed a removal restriction. No one would say that the last 3 years' worth of payments could be challenged. That money is owed as a legal matter under a valid contract, and there's no actual executive or discretionary decision being made in paying the money that's legally owed. Finally, on the anti-injunction clause, which we didn't have too much time to discuss this morning, I guess the key point I would try to make is that this wasn't a nationalization. It was a renegotiation of dividend obligations, and as all the courts of appeals before the court below recognized, and as Judge Strauss and Judge Bibas explained, the court shouldn't second-guess that under the anti-injunction clause.
Thank you, counsel. Mr. NIELSON, this court appointed you to brief and argue the case as an amicus curiae in support of the position that the structure of the Federal Housing Finance Agency does not violate the separation of powers. You have ably discharged that responsibility, for which we are grateful. The case is submitted.
The Honorable Court is now adjourned until Monday, the 11th of January at 10 o'clock.